not have an agenda, I will remind the members of the committee that they have a duty under the State Government Ethics Act to avoid conflicts of interest or the appearance of conflict, and are instructed to refrain from participating in any manner coming before the board with respect to which there is a conflict of interest or the appearance of a conflict. And does anyone at this point know of any conflict of interest that they might have? Okay. Then at this point, I'll turn it over to Peter and ask that you bring us up to date.
Sure. So the purpose of this meeting is to review the comments that we received both during our subcommittee study and subsequent to the publication of the proposed CLE rule establishing a diversity and inclusion and elimination of bias CLE requirement. The proposed rule was published prior to the January meeting of the Bar Council. The council received comments and pursuant to what is pretty standard procedure, wanted the board that proposed the rule to review those comments before taking action. So they asked that we would review the comments and if there was anything that we gleaned from the comments that we believe deserved attention as to relates to any changes or decisions to report back to the council. But if there was if after reviewing the comments we didn't feel that there were any changes or decisions that needed to be made, we don't need to take any official action. We would just it would just be reported that we have reviewed the comments and the rule is still as proposed. So I forwarded you the bulk of the comments that we've received, and then sent a couple additional ones that we received today or received over the last few days. I sent those this morning, and I'm happy to share my screen and go through the comments, or if there's anyone has any particular, after reviewing what has been sent, if there's anything that we would like to discuss or any questions that were raised by the comments that you want to discuss, then we can go to that particular comment.
I can't remember exactly what comment it was, but it was in the bulk of ones you sent prior. It was the against comment. And in particular, one taking offense that we would try to legislate their morality, and the two, it was a political thing, or this was all political, and three, the complications of trying to keep up with all of the reporting requirements. And I just wanted to look at that one because frankly, I looked at all the positive ones and they state very valid reasons. I just thought, well, for the benefit of the doubt, let's talk about the negative one.
Sure, I think that's a good idea. I have them here. We'll see.
And that doesn't necessarily mean I'm supporting that. I just think that it was sent back to us because of the comments, and I think that was the one that jumped out at me that we need to discuss.
So there are a few negative comments. There's this particular one to problematic. This one, it was a joint comment about the CLE rule and anti-discrimination language that's being studied in the rules of professional conduct. The second part was about adding specialized CLE. I think maybe, Judge, you're talking about the long comment from Paul Stam, former Representative Stam, that asked
I think that was
a fair amount of questions.
That one caught my eye probably the most, and it's, I just thought it just bears discussion.
Can I say, hi, can I say something? This is Ashley.
Sure.
Okay, so, Mr. Stam has made his points very clear, I think, and not only in this issue with this rule, but also anything that has to do with any type of diversity. He's raised these type of letters. Brian can tell you there's a longer letter that's going to the 8.4 G rule committee, subcommittee. That's even longer. Quite frankly, if you read that letter, it's extremely I just want to be honest, very disgusting. Some of the things that he said in there, as far as women having multiple children, not wanting to represent women that have slept with other men. I mean, just all type of very inappropriate things that are just. Anyways, long story short, I think we could take the time to discuss, like you said, the negatives, and I think that we should take time to discuss the negatives. But I think that entertaining him and some of the things that he points out, I think is whenever we have so many overwhelming letters in response to the positivity of this, in addition to people, like I said, supporting this, wanting to support this, I think really also we need to consider, I think that there's the condition of the 2022, and that recommendation, I think that, that year we have that one requirement. But the question for me is, do we discuss the comments in relation to that, or do we discuss the comments in relation to the other negative comments, such as, okay, well, we just keep adding things and there's a lot going on, and how often are we going to do this? How often is this going to be required? Is this an ethics requirement? Is it going to be every year when we already have technology? So that was kind of my question about it, but I don't really think that we should spend a whole lot of time going bullet by bullet and what Skip Stam has to say, when it's very clear that he has some clear issues.
Thanks, Judge. I as to your second part
can
about,
I reply right quick?
oh, absolutely, yeah.
I'm not
go ahead.
saying that we give credence to it, and I'm not familiar with Mr. Stam. I haven't had any dealings with him like you have, Judge Dunstan. I just felt like that whenever it gets sent back to us to look at comments, and we had overwhelming comments of good and support of it, that we just look at it. I'm not saying we have to go point by point, but I don't think that we need to cut something off just because we don't agree with it either. So there you have it.
Well, yeah, no, ma'am. And I'm not saying that that's what you were saying by any means. I'm just saying that, just knowing that there has been other dealings. I'm just saying that I think that we can take time on maybe some of the other comments that were negative as well, that, are just saying general things. I'm not saying that we necessarily have to agree with everything, by no means.
And that's
I'm just
my
trying to give it a
whole
historical
point.
perspective.
I didn't even, whenever he said, well, it's judged or was Philip Stam, I thought, well, yeah, I remember he had a very long one, but there were also some shorter ones that dealt with with frankly, all of the different requirements that we are having and how difficult it is to track it. So I
agree.
We talk about all of it, but I don't think
definitely agree.
Prioritize that one's more important than the other. We just need to consider them all.
And I'll just jump in, if I could jump in real quick about what we, in light of Judge Dunstan's thoughts about kind of what are we going to discuss about going forward and all of that. I do think this discussion is about the proposed rule that is indicated to be a temporary rule. We will need to come back in the next few months to start discussing the bigger potential changes to the CLE program. That includes, do we change how we require these specialty types of credits? How are we tracking them? Are we going to switch to a course application fee instead of attendance fee? I mean, there is a bigger structural discussion that we need to have in the next few months that I'm preparing for. I think today's discussion is whether we still believe that this is an appropriate rule to submit to the court. And so we would need to get this one to the council by April. As it relates to some of the questions that Mr. Stam put in, I do think that perhaps he was thinking that this rule would allow credit for just discussion of these types of court cases or classes or types of things. And I think the way that our rule is drafted is that it's related to the legal profession and how we deal with clients and things, and not necessarily the case law on gender identity. I don't think that that's really the point of this CLE type of credit. And so I think some of the questions might be easily answered in the sense that our focus is on a lawyer's conduct as it relates to these types of issues within the legal profession and dealing with other lawyers and clients and stuff like that. But I do agree that there are significant comments and questions about the concern that we're adding more and more requirements, and it's hard to do their regular competency for their practice area with another type of requirement taking up their 12 hours.
Right. I just wanted to, I think there are a couple of categories. I didn't actually write them down. That one, sort of an objection that it's not really about the practice of law and political. And then it can confuse that there's a long thing about regulating attorney's speech, and that's not what this is about. So I think maybe going over to me, just the general categories of the objections. So I think what you're doing, Peter.
Peter,
Yes.
I think that the one that has been mentioned is that, and this is the most pushback that I'm hearing from other people, is dealing with the specialization, not the topic. The topic is a solid topic. And I think that as long as the topic ties into the law, I think that we should give wide berth to the program managers on this particular hour. It's just that we've got 2 hours of ethics, 1 IT now. Are we going to add an additional hour of the 12? I mean, it seems like we are continually moving so that the folks who are trying to create good programs it's getting to be more about filling these requirements than it is about the actual improving in their respective field. And so I have always been, as a temporary rule, I think the rule is fine. I think we should move forward to 2022. The issue I'm hearing though is the bigger issue is like, what's going to be the next thing? I mean, is it going to be 6 hours of specialized? I mean, I'm going to be pushed out of the field, things of that nature. And I think I think I've also heard, there's from the bench that there are attorneys that probably need even more CLE about the way that they're handling themselves in the courtroom. So I just, I throw it out again that I think the hours should be required, but maybe it should go against one of our 2 ethics hours instead of having an additional hour. Because I'm public service. I'm sorry, Judge, go ahead.
Oh, I'm sorry. I didn't mean to butt in. I was just going to say, I agree with you. No. Particularly, I have had some of the most abhorrent behavior in my courtroom just in the last 6 months. And I've realized that the COVID brings out the absolute worst in people. But I mean, where I'm actually having to cite Rule 12 to these individuals. And I try not to, I don't want to hold people in contempt, but I really think that's a key thing that we need to look at is how they're just their behavior in general in the court. So, but thank you. I didn't mean to butt in.
No,
I just.
Oh, I'm sorry.
Oh, no, go ahead, Judge.
No, I was going to say I agree with Judge Eggers-Grider as well. I mean, and I think, like you said, I think the biggest issue is just figuring out, number one, 2022, are we good with that? Like, are we okay with sending that forward despite the comments? And then, like you said, really having that bigger discussion about this is too much. We need to have it. It needs to be a part of it. But what does that structurally look like where people are not so overwhelmed and feeling like, one more hour of this, what's next, all that. I agree with you 100%. Because the last thing I want as someone who's a huge advocate for this program is for people to say, God, I don't even want to do one more thing. Well, it's not about that. It's really about learning and growing as attorneys in all the ways that we need to grow professionally, ethically, learning more about other people and other cultures. All of those things make us better attorneys, but we don't want people, like you said, to be so overwhelmed.
Yeah, and I don't know if you can learn compassion, but I would hope that you could, because I have seen attorneys just here lately treat each other abominably. I mean, file a Rule 11 sanction on the 23rd of December. I mean, just crap like that. I mean, and that's the only way word you can use for it, as crass as it is it's just crap like that. So
it sounds like lack of civility, but it also sounds like, dealing with a professional responsibility issue as well, it sounds like.
And Judge, I think everyone is hit on, I think, the reason why we drafted the rule as it is, because it does force our hand to take a look at our structure, because I think there is this does, and I think the comments talking about adding another requirement are valid. And so by creating this as a temporary rule, so that if this is something that we truly want, then we now need to get to work on creating the structure that makes this palatable. And so I think that's the second step to this, is getting together and looking at our structure, whether we need to create a longer reporting period. You have 3 years to do certain amounts of things, so they don't have to do it all in the same year. Or rotating the special credits. We have options that we can start to look at. But I think creating this temporary rule and having it with a sunset, that if we don't get anything bigger, it will go away. I think then, that was the reason why we drafted it as it is.
Peter, I think this rule that we have and the requirement, I think it addresses what's in front of us as a profession, that the national conversation, that this is an important topic that needs to be discussed. And this is an important topic that needs to be discussed amongst ourselves as well as within our profession. And so I think by having this rule and giving us that sunset provision, then we can go forward with because what I don't want is, and I think, and I'm sort of piggybacking on Judge Ashley Dunstan, that what I don't want is that they go, oh my God, it's another specialized hour. I don't care what the hour is about. I'm already going to be negative about it. And that is not what this topic is about. It's about everything but being negative. It's trying to take the negativity out of it. And so I could talk, me, Mr. Bullock, I could talk a whole day about it. But I think as the rule stands with sunset provision, I give thumbs up.
The purpose of this meeting today is not to go in so much to the overhaul of the CLE program that we anticipate we'll be discussing later down the road. If we can ever have a retreat, that would, I think, be the perfect time to do it. Whether we will have a 3-year period in which to complete everything, whether it's going to be an average of 12 hours a year or 15 hours a year or whatever. And I'm not trying to stir the pot. I'm saying that for purposes of this meeting, I think those issues are irrelevant. But for purposes of this meeting, some of the points raised in some of the negative comments that we've received, I think need to be addressed. In particular, there was a multi-page email from Tammy Fitzgerald that began with a comment about a decision in the Eastern District of Pennsylvania. And Peter, my recollection from our conversation is that is not as to the CLE. That case did not really involve the CLE aspect, but was more on the Rule 8 aspect. Am I saying that correctly?
You're correct, George. And Brian Oten is here. He's the Ethics Counsel and has been working with the subcommittees of the Ethics Committee that are looking at potential changes to our rules of professional conduct. The email that was from Ms. Fitzgerald really, it mentioned the CLE requirements, but the way I read it is that it was really focused on the constitutionality of potential changes to the rules of professional conduct that could create disciplinary actions for what is viewed as some sort of discriminatory action. So I don't think that it would have an impact on our proposed CLE rule. Brian is here, he can correct me or add on that, but this was an email that really was designed to be focused on the 8.4 and potential comments that might be added to the rules of professional conduct.
Yeah, George, I don't know if you want any further comment on that, but I'll just say I agree with Peter. As far as his description of Ms. Fitzgerald's objections here, as far as constitutional concerns, the State Bar's Ethics Committee does have two ongoing subcommittees right now. One that's studying the potential adoption of anti-discrimination language in the rules of professional conduct, both in the preamble as well as the text of the rules. And then another subcommittee that's studying the potential inclusion of a comment to Rule 1.1 on competency that essentially states or would state that a lawyer's competency encompasses a lawyer's awareness of cultural differences and other factors like implicit bias that can impact a representation, similar to how we have a comment about technology impacting representation. And so when I read Ms. Fitzgerald's comments on the CLE, I agree. I think she's focusing on the case out of Pennsylvania that's really focusing on a rule that was adopted by the Pennsylvania Supreme Court, a rule of professional conduct that declared it to be misconduct to engage in discrimination. And they had, there's a number of different factors in their rule that I think led to the district court's decision that probably aren't really relevant to our conversation today. But just speaking from that constitutional perspective, one of the things that we've looked at in these ethics subcommittees is whether or not there are constitutional concerns for the State Bar taking these different efforts. Clearly, putting a rule in place that would direct conduct has some constitutional concerns, and that's something we're very mindful of in terms of our exploration of that topic. Requiring somebody to take a CLE on a particular topic, I think, is just a different issue. It's a different analysis. At most, you have a potential argument that, under the Keller standard that we refer to, the State Bar, or excuse me, Keller versus the State Bar of California, which kind of was a Supreme Court case that set out that mandatory bars, if you're going to use mandatorily charged and collected dues, you can only use those for the purpose of regulating the bar, that are essentially for functions that are germane to the regulation of the profession and improvement of legal services in that state. I think you have a very strong argument to say that this rule fits within the mandate set out by the court in Keller. So that's, for whatever that's worth, that's my kind of quick constitutional response. But nevertheless, I know I'm really going briefly over this stuff. If anybody has any questions about those other subcommittees or any other perspective on that case out of Pennsylvania, I'll be happy to answer those.
And if in a full candor, I am on the 1.1 subcommittee.
Right.
I don't know if that's a conflict, but and I spoke for the 8.4G one. So there's my perspective, but I just want to make sure I put that if there's a conflict, I want to make sure I put that out there.
But again, I want to reemphasize that we are not here to discuss Rule 8.4. And I think it's appropriate for us to mention that in looking at some of these responses that we've had. But we are here only to determine whether or not we want to follow up with what we've recommended to the council, or if we want to change something we've recommended to the council as it regards the 1 hour during calendar year 2022.
But Mr. Chair, I respect and acknowledge everything that you're saying, but this issue is unfortunately going to be attached to whatever actions by the State Bar, whether it's from this committee or from other committees. So I think having cross discussion is important. The other thing is that as long as we know we have a plan, and our plan is we're gonna do this, we support this requirement to 2022. There's a sunset, and this is the reason why for the sunset, because we are going to do a complete overhaul and review of how we do CLE across the board. And I think that getting down that to our counselors as well as to the membership is important, because a lot of folks believe, well, excuse me, I can't do a broad brush, but Government 101, when there's a requirement and the requirement passes muster and the requirement is attached to all the other requirements, very rarely does the government roll back those requirements. Those requirements just stay and then we move forward. So I just think we need to package it so that this is truly a sunset. This is truly temporary, and we are truly going to be looking at a complete overhaul because I think I've killed the horse. So
Well, right. Go ahead, Jordan.
As it relates to Rule 8.4, we certainly can discuss it, but this committee has no standing whatsoever under Rule 8.4, as I understand it. That's a matter for the Ethics Committee and then the Executive Committee and then for the Council of the State Bar. That rule is a conduct rule, not a CLE rule. Am I correct on that, Brian?
Yes, it is. You're correct. And I would, for whatever it's worth, we are facing a similar situation when discussing the preamble and the rule and the comment. And it is, and understandably, there's a lot of folks that are kind of really conflating all these different ideas, but we are trying to treat these as separate. And I would encourage you to treat this as a separate issue, understanding how people will view this of kind of one big push by the bar. But really, these are separate ideas that have really come from separate sources. And so I think your charge in looking at this CLE rule is specific, and that can and should be your focus.
And I would just want to, go ahead, Judge.
Peter, no, I'm sorry. I just saw that Judge Keever has to leave. Do we have to do, we still have a quorum? Do we need to vote before she goes?
There's no vote unless, there's no vote that we need to take unless someone wants to move to change what we've submitted to the council, because that's already been done. So unless there is a motion to withdraw it or amend it in any way, we wouldn't need a vote. What I would recommend that we do is in respond, in a communication back to the council, without saying that we voted again to approve this rule, just to say that we have reviewed the comments and are aware of the lawyer's concerns with adding another specialty credit, and intend, as we intended in drafting the rule, intend to take a review of our CLE program over the next few months in the hopes that we can, I'll word this in a way, in the hopes that we can provide, make it easier for lawyers to maintain their competence and satisfy all of these potential credit hours. We are aware of that concern, and that is the intent of the board, is to take a look at our program structure to see if we can make that ease that burden for lawyers.
Yeah, I was just going to say, we had this discussion before we made this a temporary rule, that we were going to discuss the full breadth of what kind of provisions we needed to have in the rules. That's why it's a temporary rule. If we have to have a vote, I will vote right now to go ahead with it. But I do have a 1 o'clock meeting that I was set before this meeting. So okay. I'll see y'all all later.
Thanks, Judge. And Paul?
Thank you, Judge Keever. Paul, you've been trying to get in for a while.
Well, thank you. Quick question. Are we being asked to look at the language itself in addition to whether we are, readopting the position that we would like this submitted, or are we just talking about this in a broad brush?
There was no specific request to examine any particular aspect of the rule, just that they wanted to make sure that we have seen and reviewed the comments. So there was no request that we take a look and see if we want to make changes. It was just, they wanted to refer the comments to the board for our review. And then if any action that we wanted to take, we could.
So it sounds like they are asking us to say we're sending it back to them as it is.
That would be perfectly appropriate. It's just, we wanted to make sure that everyone has seen all of the comments and it hasn't changed the decision of the board.
And if anyone has any comment on any of these responses that we've had as it relates to the 2022 rule, I think it would be appropriate to discuss those now. But as to the overall revamp of the CLE rules, I think as chair, I would rule that out of order.
All right, so just
I have-
pulling this down, that means the Fitzgerald letter, we don't need to consider because it's that's the ethics committee and that's not before us, right?
That's correct. I think that one we can not disregard, but just acknowledge that it was more focused, especially as it relates to the constitutional provisions, to the potential actions of the ethics committees.
All right.
Appropriate to make a motion at this point?
Well, Judge, it's a tough one because I don't, unless the motion is to adjourn, I don't know that, we don't necessarily need a motion to not change anything. But if it's up to you, certainly could. Yeah.
I guess that's kind of where I'm at, because I'm just like, if there's no comments and we don't feel any kind of way about changing it, then that's why I was like, I don't know how to move the meeting forward other than to say I make a motion that we, if that there's no, unless there's an issue where maybe we can comment on any comments about that we make a motion to send what we already said before for 2022 as it is, moving forward.
Well,
I think that's
I
appropriate.
just want to, it's not that I want to belabor anything. I just, just making sure that we did what we were charged to do. They want us to look at the comments. We've looked at the comments. Frankly, looking through Mr. Stam's letter, I'm not sure that doesn't have anything but look at the big picture of what we're looking on the overhaul, and not so much pertains to this rule. Am I misreading that?
That's the way I read it as well.
The one thing about Mr. Chair, if I may be heard, the one thing about Mr. Stam's letter is that he is giving us a view as to what type of lawsuits, if any, will be filed and where they're coming from. And so I think that's what you should just take it is to prepare.
Yeah, I think that, Bert, I think you're right. I think that there's always the risk for that, especially as it relates to the ethics committee's actions. And they've received those types of letters from Mr. Stam as well. Whether there would be something that comes from a CLE rule is unknown at this point. The rule would have to be submitted to the Supreme Court for the Chief Justice to approve. And so there's always that step that's coming in the future.
Well, it seems I do remember Mr. Stam because he was always when I was on ethics with the state bar. That's I remember, but I don't remember him being difficult. Maybe I just didn't pay that much attention at that time.
Judge Dunstan, you might want to, I think a motion that, like you had mentioned, might be appropriate, at least to formally move the committee along.
Well, I would make a motion that the committee, having considered all comments that have been provided as of this date, decide to move forward with the original recommendation of the 2022 temporary requirement, and allow Peter to add any language necessary to talk about how eventually we will overhaul everything else. But at this point, we plan to move forward with the temporary rule of 2022 for 2022.
I'm gonna rule that motion out of order because.
Well, never mind my second then.
I was right with you till you started talking about Rule 8.4.
I didn't say anything.
I don't think she said anything about 8.4, George.
Excuse me, the overhaul.
That's more overhaul of our CLE program, not the ethics.
That's not what we're here to talk about.
Well, I thought that. I'm sorry. I thought that we were talking about that we were going to allow Peter to, and I'm fine with taking that part of the motion out. I'm fine with that. But I thought that we were talking about Peter stating something that to clarify for people why that rule was 2022 was only temporary. But I will take that. I will redact that part of my motion out and leave it with we have considered every single comment. And even based upon that, we decided to move forward with 2022, the requirement for 2022 to the council.
Perfect.
Can I just wanted to point out that in the proposed rule itself, the purpose does say it's to establish a temporary rule and to allow the CLE board to examine larger revisions to the CLE rules. Now, the last sentence does say the intent is to establish an ongoing requirement for diversity, inclusion, and elimination.
Yeah, I mean, the rule kind of speaks for itself on what our plan was. Yeah.
Becky, you have seconded it.
I have, but I think what Judge Dunstan is saying is that we were charged, which is what my point was, we were charged to look at the comments we have, we're not changing it. And I think we can send that back. So that's why I seconded it.
All right. Is there any further discussion on the motion to report back to the council or the executive committee, Peter?
It would go to the executive committee, and then the executive committee would send it to the council.
That we have reviewed every single comment that we have received to date, and that our position is to proceed as we have previously indicated. Is that a correct statement, Judge Dunstan?
Mr. Chair, I'll call for a vote.
Is there any discussion there? None appearing. All who favor Judge Dunstan's motion, raise your right hand or raise your hand.
Don't want to discriminate against the lefties.
Well, I see a left hand up is why I back off on that. All opposed, like sign. All right, Peter, you are instructed. Now,
thank you. That'll be great.
May I ask the providers, do you all have any reason to believe that you would be unable to provide coursework in 2022 to meet the diversity requirements? Don't you all think you can have something ready by then?
Yes, sir. We are currently providing diversity and inclusion programming at NCAJ.
Likewise, we already have that program spun up at the Bar Association, or similar programs.
So
Mr.
that
Chair,
should not be an issue.
Mr. Chair, may I ask a question?
Yes.
To the providers, the training that you are providing in this subject matter, is that considered ethics? Would that fulfill a rule of requirement of 1 hour of ethics? Okay,
Yeah.
Thank you very much. I just wanted to double check as opposed to a general ethics hour. I mean, as opposed to a general hour.
That's right. We approve these courses. They get the ethics professionalism credit. Yeah.
Thank you, Peter. Thank you, Mr. Chair.
Mr. Chair, before we adjourn, can I add one more thing?
Yeah, certainly.
I apologize for looking rough. But I had this on Friday.
Oh, congratulations.
Thank you.
Yeah.
Oh,
What is
how
the name?
adorable. You should have started off with that.
I was trying to get my video together
Awesome.
and get my life together. So
And what is the name?
this is Isaiah Wade Dunstan.
Isaiah
Oh,
Wade.
he's beautiful.
So beautiful.
And you look gorgeous, Judge Dunstan. Don't you dare say you don't. 'Cause
Absolutely not.
I'm doing my best. He'll be 1 week tomorrow. I'm doing my best. So
Oh, that's wonderful.
Oh.
Congratulations.
He hasn't started talking back to you.
no, not like my 5-year-old, not at all.
So he's got a mentor.
I hope not. But no, thank y'all so much.
Oh.
Does anyone have anything else either on the issue of CLE or on the issue of Isaiah? None appearing. I will declare this meeting adjourned. Thank you.
Thank you, everybody.
Thank
I'll be
you.
in touch about
See ya.
setting up future meetings.
Thanks, guys.
It's great to meet Isaiah.
Thank